All right, good morning, everybody. It's nice to see your faces, or at least see your names. Thank you for being with us. This is an exciting program. I don't think any of us thought a year ago when we all transitioned to this work from home environment, that it would take a year later before we're starting to talk about getting back to normal. But I think the light's at the end of the tunnel. It's going to be months rather than weeks before we reach the end of that tunnel. But there'll be some very important things, especially with our employees and volunteers, that we need to pay attention to. So I'm very grateful that Robert is presenting, and Robert also serves on the TVNPA board. So I'm filled with gratitude that he's joined us in that capacity as well. Robert represents individuals and companies in federal and state court and various administrative agencies, focusing on overtime claims, breach of contract, trade secrets, protection, claims of sex, race, and age and pregnancy discrimination, and/or harassment and accommodating persons with disabilities. Mr. Nuddleman helps clients reduce exposure to employment law claims. So I think you could hear by his background, he's a practicing attorney. So Robert, share your knowledge and expertise with us. Thank you.
Thank you. And again, welcome everybody. And again, happy birthday to TVNPA, 7 years today. Congratulations, we're excited about that. Welcome everybody. Yeah, so as Carolyn mentioned, I am an attorney. Hopefully that doesn't cause any of you to log off. I kind of think I'm a kinder, gentler attorney, but who knows. I do represent employers, but I also represent employees. So that kind of gives me a little bit of a unique perspective in that I kind of see what both sides are going through. Oftentimes we get trapped into thinking, oh, well, my perspective is the perspective. And it's nice to be able to see it both from the employee side and the employer side, so that we can kind of bring those two together. So what are we talking about today? Well, today we're going to be talking about bringing people back into the workplace. We're going on, what, a year now that we've been in shelter in place, just a little over a year. And trying to hopefully get to back some sense of what we think is going to be normalcy. Oh, by the way, I want to mention for a moment, if you guys have questions or anything, go ahead and put them in the chat. We're going to be collecting those. We'll be moderating those at the end. We'll go through all the chat questions. So as the questions come up, just put it in the chat. I probably won't look at them until the end. And then if we have time, we'll also go into some live questions if we can. So really, we're finally seeing what we're hoping is going to be the light at the end of the tunnel. The COVID positive cases are going down. More people are becoming immunized, but we're not there yet. We're still subject to several state, federal, local, city, county ordinances. As well as employees. I'm going to be talking mostly about employees because that's what I do. I do employment law. But those same rules do apply to your volunteers. We want to take those same types of precautions. So when we're talking about how do we bring them back, what are the things that we need to do to prepare to bring them back? What do we do if they don't want to come back? What do we do if we don't want them to come back? And some issues around medical issues, whether or not people can be tested, have to be tested, should be tested for COVID-19 antibodies, or whether or not we can require people to be vaccinated. So to start, some of this may be a little bit of a refresher for those of you who are already familiar. Back in March of last year, 2020, effective the beginning of April 2020, the federal government passed the Families First Coronavirus Response Act, the FFCRA, or as I like to call it, the FFCRA. That hasn't really caught on, but I keep trying to put it out there. Under the FFCRA, employers were required to provide up to 80 hours of paid emergency paid sick leave for certain reasons. If somebody became sick because of coronavirus, or they were required to quarantine as a result of coronavirus. And in some situations, an employer could have to provide up to 12 weeks if the employee was unable to work as a result of a school closure or childcare. So if I had to stay home to take care of a child whose school closed as a result of COVID. This was a pretty broad sweeping statute that was only applied to employers with 500, I think 500 or fewer employees. The intention was that larger employers with 500 more probably already have same or similar generous leave policies. Certain cities such as San Francisco and San Jose didn't think that that 500 employee, greater than 500 employee exclusion was good. So they enacted their own version that required the same thing. For a lot of employers, particularly small employers, this was seen as going to be a pretty significant burden because they have to pay somebody for 80 hours, whether or not they're working, but they're not necessarily getting the benefit of the work. So the federal government included a tax credit that employers could get. So normally employers withhold a certain amount of taxes from the employee paychecks, and they pay a certain amount on top of that. So let's say in a given quarter, I have to pay $5,000 in payroll taxes, but I had an employee that had to use this emergency paid sick leave, and I paid $1,000 to that employee for the emergency paid sick leave. I get to deduct that as a dollar for dollar decrease off of my tax liability. So instead of sending in $5,000, I deduct that $1,000. I only have to pay in $4,000. So it actually helped out a lot that people could survive more easily. Additionally, there was the ability to get an immediate, supposedly within 7-day money from the IRS directly if for some reason you needed to provide the leave but couldn't manage to withhold that money until the next quarterly tax. That ended. The Families First Coronavirus Response Act ended on December 31st, 2020. There were several efforts to extend it. Some of you may remember there were some political things going on right around the beginning of the year, impeachments, elections, things like that, people going into office, people not going out of office. So that got delayed or waylaid a little bit, and there was no extension of that Families First Coronavirus Response Act, except the federal government did agree to extend the tax credit through, I have a typo on there that I'm now saying, through March 31st, 2021. Sorry about the typo. So what that means is at least through the end of this month, if you have an employee that needs to take that emergency paid sick leave or took that emergency paid sick leave, you can still get that tax credit through the end of this month. There are rumors that this is going to get extended in one form or another, but I have not seen anything that extends it yet. I mentioned earlier that there were city-specific versions of this as well. San Francisco notably had a version, as does San Jose. And I say did for San Francisco and does for San Jose because San Francisco's emergency paid sick leave expired on December 31st with the FFCRA. San Jose opted to extend theirs. So employers in San Jose are still required to provide up to the 80 hours of emergency paid sick leave. The San Jose version did not include that extra 12 weeks for the school or childcare. So those are just some of the kind of basics where we've been for the last year, essentially. On top of that, Gavin Newsom issued an executive order last year indicating that if anybody is working and they come down with COVID, there is a presumption that that employee got the COVID at work, and therefore it is covered by workers' compensation. There were some issues as to whether or not he could really do that through an executive order, but it didn't matter because the legislature passed a law that, at least for temporarily, that takes that presumption on. So if you are an employee and you get sick and you are working anywhere other than working in your own home, there's a presumption that you became infected as a result of work. And so it would be covered under COVID-19, or excuse me, we covered under workers' compensation. Now, that's a rebuttable presumption. So there have been situations where nobody else at work got sick and the employees' family members all got sick, or they had a contact with somebody who was sick. And so you can still establish that it's not workers' compensation. A lot of employers didn't like that there was this presumption. I actually think it's a very good thing, and it's a very helpful thing for employers, because what that means is if an employee gets sick, they can't sue you outside of workers' compensation for that illness. So I'm not saying a clever plaintiff's attorney couldn't come up with a theory, such as an unsafe work environment, but more generally, you would avoid that situation where an employee might want to sue you as a company or as an individual because they got sick coming in. Now, this is a situation, obviously this only applies to workers. So volunteers, that workers' compensation would not necessarily kick in. A few months ago, OSHA, which is the Occupational Safety and Health Association Agency, I never remember the acronyms, but they are the government entity in charge of workplace safety, issued some temporary standards and some guidelines. We're going to talk about those in a lot more detail. That has to do with what do you have to do in order to maintain, to create a safe work environment, maintain a safe work environment, and what to do if somebody gets sick. And then the legislature, again, in its infinite wisdom, has decided to make the California Family Rights Act applicable to employers with 5 or more employees. Prior to January 1 of this year, the CFRA only applied if you had 50 or more employees. And again, we're going to talk a little bit about those details coming up. So I want to address a little bit about, preparing for the return. What do we have to do? I think the best place to start really is with the OSHA Emergency Temporary Standards. This was a set of rules and regulations that the OSHA came out with on what all employers have to do. Well, not all employers. It's all employers unless you have there's only a single employee and that person has no contact with others. So if I'm the only employee and I'm not having any contact with anybody, then the OSHA standards don't apply. Additionally, the standards don't apply to people that are working from home. Part of that is the difficulty of ensuring that how can we really make sure an employee working from home outside of our control is doing everything they need to do. So OSHA says, well, if they're working entirely from home, then that's fine. And then there's the general employees that are governed by what's called the aerosol transmission diseases regulations. There are a set of regulations that have been in place for a long time that have to do with clean airspace. I'm assuming most of us don't have to worry about that. And I'm hopeful because I've never actually looked at the aerosol transmission diseases regulations, and I don't plan to unless somebody has an issue with those, and then I'll pull them up. What the regulations do is they set minimum standards for a safe and healthy work environment related to COVID-19. This is really only dealing with COVID-19, and it's only in effect as long as we are in this emergency situation. I put a website link to their FAQs. There are actually some very good FAQs. I will also, or all the attendees today will also get a couple of handouts. One of the handouts is a printout of those FAQs. They're fairly long and they do get updated frequently. And we're going to talk about some of the issues and some of the things that come in there. So let's explore this, the ETS in a little bit more detail. There's a couple of different components. First, there is a prevention program. Employers, prior to bringing the employees back to work, or even if they already have employees at work, need to have a prevention program. It's stuff you're all likely familiar with: social distancing, wearing masks, frequent cleaning, maintaining social distance, limiting the number of people that can be in any given space. What your specific requirements are might differ depending on what county you're in. For example, in Santa Clara County, employers, at least up until last week, were not allowed, they had to close down all their break rooms. People could only go into a break room in order to get something out of the fridge or pop something in the microwave. And even then they could only be in there like one person at a time. Now that thankfully Santa Clara County has moved from the purple tier to the red tier, we're not sure if that still stands. The latest information from the city of San Jose is it's still recommended that people not use it. So we don't know if that is a requirement that they don't. But that's a regulation that's unique to that that county and or that city. So we need to be aware of what our own city and county guidelines are, what is our occupancy, and these change. So I usually don't make slides that go through those in detail because again, they're changing week to week and they're different from county to county. We also, as part of the temporary standards, we need to figure out how we are going to communicate with employees. We need to make sure employees not only understand what our prevention program is, but what they need to do in order to stay safe. We also have to be able to identify, evaluate, and correct any kind of COVID-19 hazard. So this is those things we're talking about as far as keeping the workplace safe. Who do we have an employee who's going to be in charge of ensuring that? Is it everybody's responsibility? Do we have to have a team involved? It's unique to your situation. But what are we doing to keep things safe? And then more specifically, what do we do if somebody does get sick? If somebody gets sick in the workplace and it's related to COVID, what do we do? Do we have to do a company-wide shutdown? Do we not? And to whom do we have to report these workplace exposures? Depending on the number of people that get sick and who might get sick and who might have exposure, we're going to talk about that in a moment, is going to change what the requirements are. So when we're preparing the site for the workplace, the first thing we're going to look at is we have to have a model COVID-19 prevention program. What is that? Some of you may have heard of an illness and injury prevention program. It is something every employer is supposed to have. It's a plan that just says, this is what we're doing to keep people safe. And depending on the industry, they may be more complicated or less complicated. Obviously, if you're working around heavy machinery, that's going to be, or chemicals, that's going to be more complicated than an office setting. But all of them, every employer should have them. For the simple office setting, the Cal OSHA has some model programs that you can use, and you can just kind of fill those out, fill in the blanks. Well, thankfully, OSHA did the same thing with regard to the model COVID-19 prevention program. And yes, this is again one of the documents that's going to be included in the handouts. It's a Word document format, and you can just go through it and identify the pieces. I think I have, in fact, let me see if I have that up. Yeah. So you can see this is what it looks like. You put in your name, you put in when you last reviewed the policy, who's responsible for ensuring that the policy goes in place, and it identifies all the different steps that you're going to want to use. Again, this is going to be one of the handouts. What it's really going to do is it's going to get you to think about, what am I doing? Am I taking the appropriate steps? I will tell you that the steps that you're taking now may change. Again, as time progresses on, we may see different requirements because we have to comply with the federal, state, county, and city requirements. And those are changing sometimes on a monthly basis, sometimes more frequently. At the very least, for what do we know right now? Right now, we need to limit the number of people that are in the office. There's a couple of different ways to do that. You can do staggered shifts. You can say, these employees are going to come in, or these workers or these volunteers are going to come in Monday, Wednesday, and Friday from 9 a.m. to 1 p.m. And then this other shift is going to come in Monday, Wednesday, Friday from 1 p.m. to 5 p.m. or however you want to do it to mix it up so that you're being able to maintain that social distance. If people are working in their own office space and they can close a door, that's fine. But if they're in a group with other people or being exposed to other people, then we need to maintain that. Employers also need to ensure that they provide appropriate protective equipment. At the very least, that's going to be masks, possibly gloves, hand sanitizer, depending on your situation and how much interaction they may have with the public. That may also include screens, the plastic screens that we see places, although I think that those are pretty ineffective if people aren't also wearing masks, obviously. I've been told that much better it would be a face shield. I'll also need to make sure we're doing appropriate cleaning. In the beginning, we weren't sure how long the COVID virus would stick around in sufficient amount on surfaces. The latest evidence is indicating that it's actually much wiping surfaces down. There should be plenty of sanitizing napkins available for people to use. And then I mentioned already that model COVID prevention plan, having that in place. Again, on that COVID prevention plan, it can seem daunting. Once you get into it, it actually happens fairly quickly. What's the consequences if you don't have it? Well, probably not much. I mean, what's the chances that OSHA is going to come in and come knocking on your door? They do that, and they have the authority to do that. What's really going to be the reason I want you to do it sooner rather than later isn't because the government's going to ding you, but because what we want to do is provide a safe and healthful work environment. And we want to be able to show we're doing everything that we can do to keep that work environment safe. And we're going to address that in a little bit more detail momentarily. So let's say we're ready to bring somebody back to work, right? But I'm a little nervous about bringing somebody back. I get a lot of these questions. I get a lot of employers saying, look, I want to bring people back, but I'm concerned about bringing X employee or another person. And Kristen, I see your question about, do you have to submit this plan to OSHA? No, the model COVID plan is something that has to be at the work site. Again, it doesn't apply to people who are working remotely from their own homes. It needs to be at your work site. And my recommendation is it should also be communicated to the employee. So give them a copy of it so they can see what it is. But you don't have to turn it into the government unless the government asks for it. So I get a lot of questions about, well, I'm concerned, I want to bring Rob back to the office, but Rob's, I know he's a little older, he's a little frail. I think he might have some medical issues. I don't know if it's safe. That's not your decision to make. We do not want to make decisions or assumptions based solely on a person's age or even their disability, but we do need to make accommodations. What do I mean by that? If as a result of let's say I'm an asthmatic, a severe asthmatic, and the risk of exposure is so significant that my doctors are recommending I not return to the workplace. That's my decision with my doctor that I can communicate to you. Even though I'm a severe asthmatic, you should not be the one saying, hey, Rob, we don't want to bring you back to work because we're afraid of your sickness, because you are making a disability-based or sometimes an age-based assumption. We really have to leave it up to that employee to make that question or raise that issue. And then when they raise it, then we can address it. What do we have to do when we address those things? So if let's say let's jump to that. Let's jump to, if you're ready, you want this person, everybody to come back to work, or some people, and the person says, you know what, I don't want to come back to work. I'm still a little too nervous. The first thing you need to do is you need to find out why, because why they don't want to come back is going to change a lot of what our requirements are from a legal perspective. Now I'm going to put a pin in the legal perspective for a moment. I will tell you the number one reason that employees go to see an employment attorney like myself is because they believe that they were treated unfairly. So you can try to comply with the law as much as possible. Because the law is ever changing, particularly now, the chances of you making a mistake and violating the law or not knowing a particular regulation is fairly high. More importantly, is for you to treat people fairly. So engaging in that conversation, we say, hey, we're ready for you to come back to work. We'd like you to report to work on X date. And they say, I don't want to come back to work. We ask why. So we can go through an analysis of, well, is there something that we need to or can accommodate? Kat asks the questions about what about employees who are working in the field or at client sites? It is a joint responsibility. Like, let's say you have employees that are going and they're permanently over or primarily over at another client site. You should be reaching out to that client to say, hey, I need to see your model COVID-19 prevention plan. I need to work with you because we both need to work together to make sure that that is a safe work environment. Think of it as, if I'm going to send my employee over into a nuclear facility, I'm going to take some steps to make sure that the rods are correct and they don't have leaking radioactive material at the very least, so that you can ensure, because ultimately you're the one who's sending your employee over there, so you need to make sure that's safe. So what are some of the different reasons that I've heard when you ask the employee, well, why don't you want to return to work? Eh, Usually it's some type of concern of, hey, I don't want to get sick. I've got a medical condition, or at my age, I'm worried about getting sick. Sometimes it's, well, I need to, my kids are still distance learning and I need to be here and I got to take care of them. Or it could be, I'm just afraid. Or I really like it. I've even had some say, well, I'd rather you just lay me off because I want to get unemployment insurance. How they respond is going to alter kind of where we're going to go and what kind of accommodations we may or may not make. So after we know why, the first question is there any kind of applicable leave of absence? I mentioned already the California Family Rights Act. We've talked about the Family First Coronavirus Response Act. Although the Family First Coronavirus Response Act no longer requires you to provide the emergency paid sick leave, at least for the next 20 days, you may consider, I still want to provide that emergency paid sick leave, because you can still get that tax credit for that time period. So it's not really costing you anything. It's costing something right away, but you do get that as a tax credit. So allowing people to take that time off is sometimes helpful still. And again, I expect that may get extended. The OSHA regulations are specific if there's somebody gets sick at work, or what came in contact with somebody who was sick at work, where we have to provide some time off. The California Family Rights Act, which again now applies to employers with 5 or more employees, may require you to provide up to 12 weeks off for a serious or chronic medical condition. That time would be unpaid, but you still have to provide that time off and have to continue the benefits. Again, we're going to talk about that a little bit. And then you may also have an obligation to provide an accommodation for somebody who has a disability. Right now, the law does not require you to provide accommodations to people based on age. So if somebody says, well, I'm 72 years old, and so I'm afraid I'm going to get sick. The next question we're going to be able to ask is, well, do you have a medical diagnosis, or do you have a doctor's note, not a diagnosis? We never ask for a diagnosis. Do you have a doctor's note, or has a healthcare professional advised you to not return to work? Because if a healthcare professional has told them, hey, I don't think you should go back to work, we're more likely than not going to need to provide that as an accommodation. Most medical conditions in California qualify as disabilities. So we have to provide that reasonable accommodation. If there is no medical note, let's say the employee says, well, I have an underlying illness and I'm afraid of support that, well, then we aren't necessarily obligated to provide an accommodation just because the employee feels they are unsafe. But we go on to the next question, or the next part, which is we need to identify what we are doing to keep the workplace safe. That's where that model COVID prevention plan really comes in handy, because we can say, hey, this is everything we're doing. We're following the CDC guidelines, the state guidelines, the county health guidelines. We've created this model prevention plan. We're providing masks, PPEs, we're adjusting schedules. We're doing all these things to keep you safe. And you're going to ask, after having told you all this, does that change your mind? Are you still concerned? If they say no, great, then we bring them back to work, but more likely than not, they're going to say, yes, I'm still concerned. So then we go to the next question, which is there anything else that we can do to reduce your concerns? What we're doing is we're engaging in a conversation with them. Maybe there's something simple we can do. Yeah, I feel fine if I can come in, but I need to have my own office. Okay, well, maybe I'm going to kick Rob out of his office and let this person have the office. Or, well, you need your own office. What if we did a office sharing where you get the office Monday, Wednesday, Friday, somebody else gets it Tuesdays and Thursdays, we clean it in between, and then you only work from home on Tuesdays and Thursdays. Those kinds of things may help to bring the person back into the workplace. So consider those alternatives, but it may be that that doesn't work. That they say, no, I can't think of anything you can do until everybody in the office is vaccinated and I'm vaccinated, I'm not coming back to work. Okay. If that's the case, then My recommendation is we allow the employee to not return to work. We invite them to contact us when they're ready to return to work. But from an employment perspective, we are treating that as, my voice keeps cutting out. I'm sorry about that. That's probably my connection. So I will, hopefully it'll come better on the recording. I'm not sure. Kind of half monitoring the chat here. We can invite them essentially to give us a call when they're ready to return to work. Give us a call. We're ready to return. We'll see what we have available. We're going to treat that as a resignation, because when somebody's out on a leave of absence, or they're not going to be able to come back to work, they're not on any type of a protected leave, we may need to go ahead and pay out any accrued paid sick leave, or paid time off, not paid sick leave, and not keep the position open. I wouldn't hold the position because we need to get the work done. But when that employee is ready to return to work, I would try to give them preference if we can. I'm already defending my first COVID-19 lawsuit that dealt with a situation where the client worked at is a facility, essential workers working with developmentally disabled adults and children. They need people, they need the supervision, and some of the employees decide that they didn't want to work unless everybody was able to test positive and remain negative for a period of time. And that just simply was not a possibility. They had to have people, because otherwise the entire business would have to shut down, and these at-risk people would go without services. So they had to make a difficult decision and say, no, if you don't want to come back to work, that's up to you, but we need to get the work done. And so they had to bring in other people. Now they are facing a lawsuit as a result of it. But if an employer follows my kind of little 5-step process, I think you're in the safest place. Because what you're doing by identifying what you're doing to keep the workplace safe and pointing out that you're following all of the county and required guidelines, you're establishing that this is as safe of a workplace as we can create. By asking them if there's anything else you can do, and if they can't identify anything, you cannot fire somebody because they refuse to work in an environment that is unsafe, that they reasonably believe is unsafe. You are, by identifying what you're doing to keep it safe and asking them if there's anything else that you could do to keep it safe, you're eliminating that reasonableness of how safe or not safe it is. And again, we're not firing them. We're ending the employment, which actually allows them to get unemployment benefits, and actually is to their benefits. There was a question about medical benefits. We're going to talk a little bit under OSHA and the CFR. We are going to be addressing that question in a little bit. So I just want to let you know I saw that, and I will be getting to that question. Big question I get oftentimes: how about testing? Can I require employees to get tested? And as we're getting vaccinations, can I require employees to get vaccinated? The question is yes, but for the testing, first of all, here's where the issues come in. We have the Americans with Disabilities Act and the California version, which is part of the Fair Employment and Housing Act, that says we cannot make decisions of people's ability to work based on medical conditions. But we do have an obligation to provide a safe and healthful work. Sometimes those two can contradict each other. The law limits when we can do what's called a fitness for duty exam. Equal Employment Opportunity Commission, the federal agency, has said, yes, you can do that, but it has to be a business necessity, and it has to be done consistently. So you can't just choose, oh, you're over the age of 70, so I'm going to require you. Is my vocal? Okay, here's what I'm doing. I'm going to change my audio over to my phone. So give me a second to figure out how to do that. Give me a moment. Hopefully that'll stop at least the voice cutout part.
Robert, we only lose you for maybe a few seconds. So if
Okay.
it turns out that your audio on your phone isn't easy to get to, it hasn't been significant. But Julie did point out it was the fitness for duty exam that did cut out.
Okay. Okay, so hopefully you can hear me now. So Carol or Cheryl, is somebody tell me, make sure you can.
Yeah.
Yes.
Yes.
Okay, good. Okay, good. So hopefully this will be better. And hopefully this will be better. Sorry about that. Yeah, so the fitness for duty, you can require somebody to undergo a fitness for duty.
Now I have to mute me.
I just muted you on.
Okay,
Okay, you should be okay.
there we go. Sorry about that. I gotta love technology sometimes. So yes, you can do a fitness for duty examination if there's a business necessity for it, as long as you're consistent. You have to have, everybody is going to go through this, or nobody's going to do it. You can't make the decisions based on, oh, just you. Now you could do it for a group, like, oh, you have contact with customers or clients, so therefore we're going to require a COVID-19 test from you. But these other people that are isolated and have their own office, we don't have to worry about them. You also have to make accommodations for people if they have a disability or a religious belief that prevents them or interferes with their ability to get tested. Again, we have to make accommodations for persons with disabilities. If the person says, for medical reasons, I cannot get tested, we may require a doctor's note for that, but we have to make that accommodation. The same is true for somebody who has a religious belief that prevents them from getting tested. If an employer requires, does the employer have to pay for the testing? Yes and no. If somebody is sick because of a workplace exposure, we're going to talk about in a moment, yes, the employer has to pay for it. Most places you can get the testing for free anyways, but if somebody has to get tested as a result of a workplace exposure, then yes, the employer not only has to pay for the test, but they also have to pay for the time. The employee has to pay their wages for the time they're getting tested. And the same thing is true for the vaccination. Can you require it? Yes, you can, but again, it has to be consistent. There has to be a business necessity, and you have to be able to make exceptions to that rule for somebody that has a disability and or religious reasons that prevent them from getting tested. So what happens if somebody does get sick? What do we got to do? Well, this is where those Cal OSHA regulations are going to kick in. And I do encourage you to take a look at those Cal OSHA FAQs because they really are helpful. Step number one is we have to determine whether or not somebody calls in and says, hey, I'm sick, I believe I have COVID. We have to find out, did this result from a workplace exposure? Well, how do we do that? When did you start feeling sick? Have you been tested? That's going to dictate when or whether or not there's been a workplace exposure. I think the current rules say that any exposure within 48 hours prior to when the person started experiencing symptoms could constitute a workplace exposure. The other thing, it may be obvious. Maybe they went to a family outing and somebody was sick there, or they've been off work for a week. So we know that they have not been exposed to workplace, but maybe they have exposed others in the workplace. Maria, you asked a question about what do we do if somebody doesn't want to get vaccinated? And we're getting this a lot. Right now, I don't think you should force people to get vaccinated. There are other people who disagree with me. The reason I'm saying that is because we don't know if that vaccine protects. If I get vaccinated, I don't know yet whether or not that's going to protect me from getting you sick. It's just going to protect me. Now, if you choose not to get vaccinated, I can tell you, hey, that's fine, but you're not going to be able to work and you're going to be on an unpaid leave of absence, and or we're going to consider this a separation until such time as you're ready to return to work. Again, assuming that we have a business necessity for there to be a vaccination. Until we get confirmation that the vaccine will protect you from me, I'm vaccinated, and that will protect you from getting sick. I think it's difficult for me to. I don't know why I got muted there, but hopefully that came back out. I'm going to try and switch over to my computer audio again.
We can hear you, Robert.
Okay. Okay. So first step, we've determined if it was a workplace exposure, because if it is, then there's a couple things we have to do. First of all, we have to determine with whom did this person have contact in the workplace for a cumulative of 15 minutes over a 24-hour period. So we essentially have to do our own tracing. We have to ask that employee, where were you? Who did you have contact with? Now, contact doesn't mean passing somebody in the hallway if everybody's wearing masks. But if I'm talking to you for 5 minutes right now, and then an hour later I talk to you for another 5 minutes, and 4 hours later I talk to you for another 5 minutes, that is a cumulative 15 minutes. And that counts as an exposure, which triggers my obligation to notify the other employees within 1 business days that they have potentially been exposed. So anybody with whom they've had contact, this 15 minutes of contact within a 24-hour period in the workplace, we have to notify them within 1 business day in writing, but we also have to protect their confidentiality. Sometimes it's going to be obvious because, oh, this person is no longer here, and you're saying that I may have come in contact with somebody. Nonetheless, we don't use names. We just say you may have come in contact with someone. We don't use pronouns that indicate gender. We just say, you know, you may have been exposed, and we have to offer to have the employee go get tested. In fact, until they get tested, we may need to exclude them from the workplace. There are different guidelines as far as how long they have to be excluded from the workplace. I believe it's 10 days from the date they first experienced symptoms, or 10 days from when they first were tested. I think I have a slide on that shortly. During that time when they're out of the workplace, whether it's the person who got sick there or they were just exposed to the workplace or exposed to COVID-19, you have to continue their pay and their benefits during that time. Yes, the CDC guidelines do spell this out, but they may be different than the OSHA guidelines. CDC is a federal agency. Our Cal-OSHA guidelines are a state agency, and they may have different guidelines, and you have to comply with whichever is most strict. Also, you have to, or you should, notify the county public health. Now, what they say is you have to notify the county public health for any mandatory for an outbreak. We're going to talk about what an outbreak is in just a moment. I think that even if you have a single exposure, it makes sense to notify the county public health to say, hey, wanted to let you know we had this exposure. We've already found out that this person didn't have any contact with anybody else. Nobody else has gotten sick, but is there anything else you need us to do? Usually they're going to say no. You also are required, if you have more than 5 employees, you are required to notify your workers' compensation carrier of the potential exposure. You don't have to provide any identifying information about the employee, but you do have to notify your carrier. And finally, you have to investigate and address any type of hazards. Was there something that we could have done differently with everybody wearing their mask? Or people not wearing the mask? What do we have to do in order to make sure that they're safe? So what is an outbreak or an exposed workplace? Well, an outbreak is when you have 3 or more COVID-19 cases in an exposed workplace within 14 days. An exposed workplace is really any area in the workplace. It doesn't have to be the entire work site. It could be an office. It could be the break room. It could be the manufacturing floor, or it could be the entire facility. Usually when we're looking at whether or not we have 3 or more within a workplace, we're looking at an identifiable site where those people are congregating. So anyone who had access to or worked in the same location counts within that 14-day period. When there is an outbreak such that you are required to have your employees get tested weekly until there is no longer an outbreak. They also have rules for a major outbreak if you have 20 or more situations within a 30-day period, which can require some heightened situations. Going into when can we let somebody return to work? This is the basic rules as they stand. They have been modified a couple of times in the 2 months that these regulations have been out. But if somebody is exposed to COVID-19 and they're experiencing symptoms, they have to have at least 24 hours with no fever, without any ibuprofen or anything to reduce it. Their symptoms have to have improved, not be gone, but improved, and there has to be at least 10 days since the COVID symptoms first appeared. All three of those have to occur before that person who is experiencing symptoms can return to the workplace when we're dealing with a workplace exposure. If somebody was exposed but they don't have symptoms, then they have to wait at least 10 days since the person who did have exposure, or since the first positive test. There can be exceptions if a licensed healthcare professional or the CDC or public health says no, they can come back sooner, or they have to stay longer, and that can occur. Sometimes somebody may have to stay out longer. And again, you have to continue their pay and benefits during that entire time. As promised, I want to talk a little bit about the California Family Rights Act. This is a law that used to only apply if you had 50 or more employees within a 75-mile radius. As of January 1 this year, it applies to all employers who regularly employ 5 or more employees. It requires you to provide up to 12 weeks of unpaid time off to care for themselves or a family member that has a serious or chronic medical condition, or to bond with a newborn child or a newly adopted child. It's within the first year of their birth or adoption. Or if there's a qualifying exigency for close family members dealing with military service. Those are the basic reasons that you would need to provide that time off. It is an unpaid leave of absence, so you don't have to pay them, but you do have to continue their health insurance as though they were continuing to be employed. So if you normally pay 100% of the health insurance, you have to continue to pay 100%. If they pay 50%, you pay 50%, you have to pay your 50%, and they have to pay their 50%. You are required to guarantee their you're required to guarantee their job when they as long as they can return to work within those 12 weeks. You have to guarantee their job. That may mean you have to bring in somebody temporarily, but with very few exceptions, you need to return that person to work. Now, if you can show that that person would have lost their job regardless of whether or not the person went on leave, so you're doing a mass layoff and that person was already considered, yes, you may be able to go ahead and let them go. The California Family Rights Act, when you're caring for somebody else or caring for yourself, that is separate and distinct from your pregnancy disability leave. The pregnancy disability leave also applies if you have 5 or more employees. That law allows employees to take up to 4 months of time off when she is disabled as a result of pregnancy. So an employee could take 4 months of pregnancy disability leave, again, unpaid, and still take another 12 weeks of CFRA leave to bond with a newborn child. So for those of you who are counting, that's up to 7 months of unpaid time off during which the employer is required to continue the health benefits. Now, if the employee does not return to work either from CFRA or the pregnancy disability leave, they choose not to return to work, the employee is responsible for reimbursing the employer for any of those health benefits. So under the CFRA, who qualifies as a family member is broader than what the laws used to be. It includes parents, children, grandparents, grandchildren, siblings, spouses, registered domestic partners, and the parent-in-law. So it can also be your registered domestic partner-in-law. So it's a pretty broad question. Let me see the question. Yes, you have to return them back to the same position, or if that position no longer exists, then you have to return them to a same or similar exemption position. There's a question about if the medical benefits are partially subsidized by the company and the employee cannot or doesn't pay, what do we do? I'll try and do this as quickly as I can. When somebody says, hey, I got to go out on this leave, whether it's pregnancy, disability leave, or SIFRA leave, we're going to give them notification of, okay, while you're out on leave, this is when it's going to start, this is when it's going to end. You're required to pay X amount of dollars towards your benefit, and we need to receive that check on or before this date. If we don't receive it, then that may delay or end your benefit. And so if the employee doesn't turn in, it's the same thing as what would you do if they were working and they didn't pay their portion? If they had no income or they didn't authorize you to take it out of their deduction. So you have to notify the insurance company, they didn't pay their benefit, so therefore they're disqualified. Now, would we cover that probably for 1 month? Yes, because I think that's, you know, a reasonable thing to do. But then we should notify the employee, hey, you didn't make your payment. If we don't get that payment within the next 10 days, plus the payment for the next month, we have to notify the insurance carrier that you've elected not to have coverage, and you're going to be responsible for getting your own coverage. That is something that should be done in a phone call and followed up in writing so that we make sure everybody is on the same page. If you are kind enough and you go ahead and cover their costs during the whole time they're gone, and when they return, yes, they still have to pay you back the portions that they should have paid while they were gone. So those are the main parts that I wanted to go over on the getting people back to work. I did want to touch briefly, if I may, on independent contractors, only because it's still kind of a bit of a hot topic. Many of you may remember we've talked previously about AB 5 was enacted January 1, 2020, which substantially changed the test for determining whether or not somebody is or is not an independent contractor. There raised a lot of eyebrows and a lot of people were upset. That law did get amended by AB 2257. It is a Band-Aid, but not a very good one. The ABC test, which is it's still the default test to determine whether or not somebody is an employee or not. All AB 2257 did was modify or update some of those exceptions. Again, one of the handouts that you're going to get is my breakdown of the different tests that would be involved, you know, what are the different exceptions. I'm happy to field questions on any of those if you'd like. But the basic rule is that if they're performing work that you're in the business to provide, more likely than not, they're going to be your employees unless they fit one of the exceptions. The most common exceptions that I'm seeing is the business-to-business exception and professional services. That does not apply to everybody. You know, there are certain listed professional services, marketing, human resources are a couple that come to mind. And then a business-to-business is also another possibility. But again, there are certain requirements. The handout that I'm going to give you has what those tests are. It's in my own kind of note form, but I thought it would be helpful. So if you have any questions about that, please give me a holler. Some of you may have also heard about or seen about Proposition 22. Prop 22 is an initiative put on the ballot backed by Uber and Lyft and DoorDash and many of the others that allows app-based drivers to still be independent contractors as long as certain requirements are met. It only applies to app-based drivers. So Prop 22 is not going to help anybody else out. Will there be additional propositions for additional exceptions? Possibly. I mean, I do know that the legislature is still considering other amendments to it. Who knows if they're really going to make it? I don't study those too intently until they actually get passed because there are so many changes along the way. You know, in the meantime, well, what do we do to make sure we're safe? Well, number one, independent contractors should always have a written agreement. In my opinion, the contract should come from the person you're hiring. You know, if I hire a plumber to come into my house, I don't hand them my contract to sign. It is a contract that should come from the person because they should be, the reason they're an independent contractor is they are a separate business with their own clients. They're helping other customers or advertising in order for almost all of the tests to be accepted from the ABC test, they have to meet those things. So really, I prefer they have their own agreement. Now, if they don't, is it better for you to at least have one that they sign? Yeah, it's better. I wouldn't put it on your letterhead necessarily. And the agreement should go through kind of those exceptions that are in the handout that I'm going to send you and address those issues. So if it says that the person has to provide their own tools and equipment, should have a provision in there. They're making sure that the service provider is saying, I'm going to provide my own tools and equipment. If we're going to be hiring them to do marketing, and marketing is one of the exceptions under the ABC test, then let's specify, I'm hiring you to do marketing, those types of things, so that we can make sure we're kind of belt and suspenders, we're doing everything that we can. So that brings me to the end of all of my questions that I wanted to make sure that or all the issues I want to make sure. I want to be able to open it up. I tried to answer as many of the chat questions as I could as we went along. But if people have other questions that they want to ask, I'm going to open it up, and I don't know Carolyn, if you're going to field those for me.
I am. So I'm going to start. So David, I see your hand raised. So we'll go with David, and then also people can use the hand raise function by the participant list as well. So David, your question for Robert.
Hey Rob, nice to see you again. Geez, been a while.
I know, it's good to see you.
Yeah, I have a question about the people I work with. All of them are going to be vaccinated by the end of this month, just because we're doing community health services. Do all these rules still apply if everyone's vaccinated? Do we still have to do everything? Like,
yes. Yeah, and that's a great question. That's a lot of questions. That's the other reason why I'm saying forcing people to get vaccinated doesn't change anything. As it stands right now, you're still required to have that model COVID plan. You're still required to do the social distancing. You're required to have masks. You're required to do all those exact same things. We want people to get vaccinated so we can hopefully reach that herd immunity that we've been hearing about. But getting everybody vaccinated does not relieve you of the obligation to do all the things that the city and county is still requiring us to do, and OSHA.
all right, thanks.
And Robert, have you heard anything about any timeframes where, are you anticipating that those rules and regulations will evolve as a higher percentage of people are vaccinated?
Yeah, I mean, and they will. I mean, a lot of them are dependent on what our counties are doing as far as what requirements we have to do. And, you know, it is an ever-changing situation where sometimes week to week, and certainly county to county, what the rules are and the regulations are going to differ. I think as we see more and more people get vaccinated, and we get closer to that 70% herd immunity that we're hoping to get, that we may see an ease of those restrictions. But you know, I wouldn't put it past the government to say, yeah, you can ease these restrictions, but only if the majority of people are vaccinated. Which, if they do that, then makes it really simple. But what the legislature is really going to do, I don't know.
All right, Maria, you have a question. You're up next.
Yes, thank you. Hi, Robert. Good to see you again. So really quickly, how does all this apply to our volunteers?
Yeah, I mean, I would treat volunteers as employees for the purposes of whether or not there's an outbreak, for making sure things are safe, for notifying public health. They wouldn't necessarily be covered under workers' compensation. There is, I would warn everybody, there is always a risk that who we think is a volunteer really is an employee. That ABC test that the government said didn't have anything about volunteers, that AB5 that I was talking about, there's no exception for volunteers as far as what qualifies as an employee under that ABC test. We haven't had to deal with it, or we haven't had any cases that have addressed the issue of whether or not a volunteer is an employee under the ABC test. All we've got is some very old labor commissioner decision letters that if you're a nonprofit, which many or most of you are, then you can have volunteers. Most for-profit companies can't really have volunteers. So for that reason alone, but also I think for the safety of our employees, we want to have the same standards applying to our volunteers that we have to our employees, at least for purposes of notifying the county public health ensuring whether or not there's a workplace exposure or not. Because the workplace exposure isn't limited to a workplace exposure with an employee. If you have let's say your copier repairman comes on site and is working in the copy room, and then 2 days later you find out that that copy repairman had COVID, you still have the same workplace exposure issues.
Okay. Okay. And one other question. So did I understand correctly, when you're talking about if somebody was exposed, if one of your employees were exposed to COVID but didn't have any symptoms, and you asked them to quarantine for the 10 days, are you supposed to pay them for that time even though they're not infected?
Yeah, if it was a workplace exposure. So
oh, I see.
If they were exposed because they were outside of work and they went and visit family, you don't have to pay for that. But you can say you're not allowed to come to work for 10 days until at least 10 days after you tested positive. But if it was a workplace exposure and you're not allowing them to come to work because the law says we can't, then yes, you have to continue their pay and benefits for at least those 10 days.
Okay, thank you.
So Robert, before, I've not seen any other hands raised right now, but another question that has come up is what about hazard pay? So you're asking employees to come back, but they still, or you gave the example of the client that you're working with, right? That is working with adults with disabilities.
Yeah, the law in general does not require hazard pay. Some employers do that. Some union contracts require that. Some public employees, they get hazard pay. San Jose just passed an ordinance for any groceries or pharmacies in San Jose. If you have 300 or more employees, and that includes franchisors, it doesn't even have to be 300 employees in San Jose, just 300 employees entirely, that they have to provide an additional, I think it's $5 an hour for if you're working in a grocery store or like a CVS or they even have Long's Drugs, Walgreens, because they're considered essential workers and they can't take the time off. So that's just the city of San Jose. I mean, all too often, sometimes our California legislatures can follow what San Francisco and San Jose does or LA does. So it may happen. Right now, San Jose is probably the most restrictive or most employee friendly as far as the regulation. So that if you're not in San Jose, then you don't have to worry about it.
All right. And then what about, so as employers, we should all have employee manuals or handbooks. Do we need to be updating those as we're going along, or what do we do with it in this period?
Yeah, so first of all, I would say I'm a big fan of Cal Chamber. If you're not a member of Cal Chamber, they have some great resources. And they have, one of the things, they have an easy handbook creator. And they have, as part of their recommendations, a COVID policy. And I think Paychex and ADP, they also recommend it. I actually am not a fan of including a COVID-19 specific policy. One, maybe I'm hoping against hope, but I'm thinking this is really temporary. And I don't want something that's temporary to be in a permanent handbook. Now, should you have things in your handbook such as you need to follow and adhere to state, city, and county and federal safety guidelines? Absolutely. So, and that's what I've been doing is I've modified the handbook so that I just put in there, all employees are required to follow federal, state, and local guidelines for healthy and safe workplaces. If you know of an unsafe work environment, you're obligated to report it. I don't go much beyond that because we have hopefully this model COVID-19 prevention plan. We may make reference to that in the handbook of saying, for information, you can see our modeled our COVID illness prevention plan, or just say our illness and injury prevention plan. Most of the time, most handbooks don't keep the illness and injury prevention plan as part of the handbook. I also know I've had a lot of companies lately asking about, hey, do we need to have a handbook? My rule of thumb is, once you have 5 employees, you really want to have a handbook. If you've got 15, you need a handbook. But really at 5 employees is when I recommend it. Below that, you can get by without it. I think it still is helpful to have a collection of policies, whatever those are. And it's always good to have those reviewed by a HR professional or an attorney. But the leaves of absence laws that we're talking about, the pregnancy disability leave, the California Family Rights Act, the requirement to provide accommodation kicks in once you have 5 or more employees. Now, if you have a lot of volunteers, you may want to have your own separate volunteer handbook that covers general dress code and best practices, but you're probably not going to have leave of absence policies in your volunteer handbook.
So what about if an employee does not want to be vaccinated and you have a few? Can you, and there's still the workers' comp issue, if there's a workplace exposure, can you ask that employee to sign a waiver or other waivers related to COVID-19?
Yeah, I had a lot of people asking about, even before there was possibility of a vaccination, can we have them sign a waiver? No. Number one, as long as there is a presumption that it might be a work-related exposure, or the law says if you're working and you get COVID-19, there's a presumption of it being a workers' comp claim. You cannot require somebody to waive their rights to file a workers' comp claim. And technically, you could be seen as an interference with their ability to file a workers' comp claim if you were to even ask them to sign a waiver. And I will tell you, most of the times, a waiver is not really effective anyways. And if I say, if you come out of my workplace, you're not going to sue me if you get hurt, that only goes so far. It's good to be able to identify risks. I think it's fine to let people know, hey, there's always a risk of exposure. If that happens, this is what we're doing to keep you safe. But a waiver is not going to really be effective to do anything. Whether or not you prevent somebody who's refusing to get vaccinated, whether you refuse to allow them to come into the workplace, we kind of have to go through that 5-step analysis that I was talking about before and make a determination of, can we accommodate it? Do we not? Are they refusing to get vaccinated for a medical reason, in which case we have to make an accommodation, or for religious reasons, in which case we have to make an accommodation? Or is it, no, I just don't believe, I'm taking vitamin C and I think that is sufficient. You may decide that's fine. Then you've chosen not to return to our workplace. We'll let you know when we're able to allow unvaccinated people into the workplace.
All right. Any other final questions for Robert, either in the chat or anybody would like to ask? All right. I'm not seeing any hands raised there. Robert, do you have any final closing kind of comments before I throw this back to Kathy?
Only that this is a changing landscape. Things are moving. They will continue to move. So what I'm telling you today could change. What I'm trying to do is keep things broad enough to give some general guidelines of how things are. I would say continue to monitor county guidelines before you bring back employees or volunteers. Look at what your requirements are for your county. Be prepared for continued changing. If you want to look at the OSHA stuff, the OSHA, if you just type in Cal OSHA COVID, you'll get to the Cal OSHA site that deals with the COVID stuff. EEOC has some stuff. So if you type in EEOC COVID into a normal Google, Bing, Yahoo, I don't know, do they do searches anymore? Search engine, you'll come across those. And I believe, like the FAQs for the Cal OSHA stuff is part of the handouts that you're going to be getting as a part of this. And will this be available? They're asking if this can be available for people later on. Or certainly, it is our hope that other people will be able to view this, if you missed part of it or all of it.
All right. Thank you very much, Robert. And we will be distributing the handouts that Robert referred to, will be distributed to all the attendees today. So, Kathy.
Thank you.
All right. Well,
thank you, everybody.
Yeah. Thank you, Robert. I'll say thank you real quick. Hooray. And yeah, thanks for trying to break down this crazy topic that we're all trying to figure out right now. And thank you everybody for attending. We have been placing, if you go to our website, and there's a page for videos, and we have some of our last programs on there. We may end up moving those ultimately to our membership site, but right now they're available for anyone who wants to watch them. So go check it out. And that's it, I guess. Thanks, everybody. Have a really great week. We look forward to seeing you next month.
Happy birthday, TVNPA.
Thank you.
Happy birthday.
Yay.
Thank you, Robert.
Thank you, Robert, very much. Thank you. Great expertise. Thank you for sharing.